I think one of the things that attracted the interest, as you mentioned, was this in relation to international law, because I think in that lecture, and certainly elsewhere, you state that in your opinion the British government and the American government broke international law when they went to war.
Yes, I didn't say that in the David Williams lecture. I kept off the subject because I was a serving judge at the time. But I've given a lecture since that is actually a chapter in the book. And I certainly did make that suggestion.
In what way did they break international law? By not having the second?
By not, I mean, I think the United Nations Charter is perfectly clear. It says that you can go to war in self-defense, or, if authorized, by resolution of the Security Council. And there is a third, rather disputatious possibility that you can go to war to prevent a major humanitarian catastrophe. You can use force in order to do that. Well, nobody has plausibly suggested that there was any question of self-defense in March of 2003. And nobody has suggested that it was necessary to use force in March 2003 to prevent a major humanitarian catastrophe. So the only question is whether it was authorized by the Security Council. And my clear view is that it was not.
Wasn't Blair's argument that 45 minutes might see some of our smaller territories bombed by Saddam Hussein a kind of self-defense argument? That he had the weapons to attack Cyprus and so on?
But he wasn't threatening to use any weapons against anybody at the time. And although he had used weapons of mass destruction against his own population, he hadn't done so since 1991. And if you recall, in March of 2003, there were United Nations weapons inspectors crawling all over Iran who hadn't found anything and who believed that in a matter of I think they said months, they would complete their investigation. So I don't think self-defense is. I don't think even anybody has actually suggested it was. Certainly the Attorney General in his advice didn't suggest that there was any element of self-defense about it.
Well, you mentioned that, and that's one of the most puzzling aspects of all this, that the Attorney General in his first advice said that he felt that there was not a sufficient case, and then 10 days or whatever later gave advice of half a page or so saying he'd thought about it, he'd changed his mind.
No, with respect, he never said he changed his mind. I mean, there were those who said he had changed his mind, but he never said that. The Attorney General, Peter Goldsmith, was a member of my chambers. We were in the chambers together, so that he wasn't best pleased with me for saying what I did. And indeed, I'd sent him a copy of what I was going to say in advance, and he protested rather strongly. And I included his answer in the lecture. But I mean, it's all quite technical, but his argument was that there was authorization in Resolution 1441. In his first advice, he said he canvassed the possibility of this authority being revived by Resolution 1441, but said the matter had to go back to the Security Council to be considered. And in the event, it never was considered by the Security Council. What Resolution 1441 said was that Saddam Hussein should have one final opportunity to comply. Well, the question, of course, was who was to judge whether he'd availed himself of that opportunity. The answer, in my view, could only be the Security Council was to judge whether he had availed himself of it. It wasn't open to the United States or Britain to say, well, we don't think he's availed himself of it. So, I mean, Peter never has accepted and wouldn't accept there was any difference between his two advices. But they don't lie happily together, in my opinion.
Mm-hmm. I don't want to pry on it too much, but another strange part of it was it seemed to be that he then at some point turned to the Prime Minister and asked him what his opinion on the matter was. And the Prime Minister said, well, I can assure you that my opinion is that it's legal, and that this plays some part in his thinking.
It isn't quite like that. Which is a reasonable position in principle. I mean, a lawyer is usually not in a position to say what the facts are. And so a lawyer often, when he's advising, will say to a client, well, if it is the case that factually A, B, C and D, if those conditions are satisfied, then as a matter of law it follows that this is right. And that's what Peter, I think, was trying to do with the Prime Minister. He said, if you are satisfied that there has been a material breach, then it is legitimate to go to war. And was leaving it to Blair to say whether there had been a material breach or not. And Blair thought it was. But I'm not. We may get to know this when there's an inquiry into the whole episode, if there is. But I'm not at all sure to what extent Tony Blair really applied his mind to this. Peter Goldsmith was emphatic in his advice that regime change was not a legitimate object of the invasion. And I myself find it very hard indeed to think that Tony Blair did not appreciate that regime change was what the Americans were proposing to achieve, because they never made any bones about it. They just wanted to get rid of Saddam Hussein.